Good morning and welcome to my channel. Today we're going to be discussing housing and reasonable accommodation and modifications. We're also going to be discussing several of the in-principle laws, which is Section 504 for reasonable accommodation housing, the American Disabilities Act, and the Fair Housing Act as well. So these are three federal laws, and I want you guys to understand these laws, these federal laws, are particularly aimed at people no matter where you live or where you work. It doesn't matter if you're the person that is at the top, the person that is the main leaseholder, or if you are a person that moved in with somebody and you're the subleasee. As long as there is a disabled person included in the picture, in the situation, these laws are applicable. It does not matter, and I also want to tell you, it doesn't matter if it's normal housing, college housing, dorm housing, if you're in Section 8 housing, HUD housing. So it doesn't matter the type of housing, whether you're renting it, you're owning it, any of that. These laws are an umbrella of all types of housing and all types of working and living situations. And it also includes businesses that are serving the disabled as well. But the purpose really behind this video is this. I'm really trying to address this for people that are in Section 8 and HUD housing because I get an abnormally high number of requests about this subject because a lot of housing authorities are beating around the bush and they don't want to give voucher holders a good opportunity. And so we have problems also with landlords. Let me tell you something. These laws are applicable to anybody. Most of you have known me. I've been around for almost 20 years doing this, okay? 18 out of 20. So when I do consulting work, this is one of the bigger issues I have to deal with constantly, is dealing with unfair and ridiculous housing authorities and also landlords. And let me make something else clear. HUD is in Washington, D.C. Your local housing authority is administered by the city. They do not have any special rights. They're not exclusionary to the rules, and federal rules do apply to them. If they don't want to cooperate with federal rules, then all hell can rain down on them, okay? So you don't necessarily have to go directly to an attorney to pay thousands of dollars. You can reach out to me. I am a consultant, and so it's a little bit less costly. But if it does reach the ultimate point of having to file court paperwork, then of course you would need to consult with an attorney. So let's move on with all this real quick. We got rights and obligations under federal law. Various federal laws require housing providers to make reasonable accommodations and reasonable modifications for individuals with disabilities. Federal non-discrimination laws that protect against disability and discrimination not only cover the tenants, but home seekers with disabilities. It also covers buyers and renters without disabilities. Remember what I said, that if a disabled person enters your home or enters your business, then guess what? There has to be an accommodation or a modification. And we'll get into what's reasonable and what's not in just a minute. These laws also prohibit housing providers, meaning the housing authority. A lot of you guys think these housing authorities have some kind of special power where the rules don't apply to them. You're absolutely wrong. They can get in quite serious trouble behind this stuff. And anyways, the laws also prohibit housing providers from refusing residency to persons with disabilities or placing conditions on their residency because they require a reasonable accommodation or a modification. Let's make some clarity, okay? Now, I understand, you need to understand that modifications and all that are one thing, and it's another thing when your toilet's broken and there's roaches running around, okay? These rules are not going to be, that's not the common type of accommodation, so I just want to make sure we're clear that if you have complaints about repairs, unless it is affecting you from the disability aspect, then we cannot be inclusionary with this language or federal law, okay? But, if it is affecting how you're operating as a disabled person, roaches don't do that, obviously. An overflowing toilet's not going to affect you so much as a disabled person. But if there are other issues related directly to impacting your quality of life there, then it could. Fair Housing Act. Under that Fair Housing Act, a reasonable accommodation is a change, exception, or adjustment to the rule, policy, practice, or service. The Fair Housing Act makes it unlawful to refuse to make reasonable accommodations to the rules, policies, practices, or services when such accommodations may be necessary to afford persons with a disability an equal opportunity to, and here's the key word, enjoy the dwelling. In other words, they've written this law very well. almost any, you know what, to be frank with you, the fair housing law, it is open to interpretation, but you could say that just about any situation could be unenjoyable. So I've got to tell you, the law's pretty strong. There's not much of a rebuttal the housing authority or also any individual landlord or business owner could rebuff this with. Because, I mean, it's very, very clear that it covers just about everything. Now, moving on. In addition to the Fair Housing Act, it prohibits a housing provider from refusing to permit at the expense of the person with a disability reasonable modifications of existing premises occupied or to be occupied by such persons if modification may be necessary to afford the person with full enjoyment of the premises. It keeps going back to that mental aspect of being able to fully enjoy. And when they mean fully, they don't mean 2 bedrooms out of 3. They mean in fully enjoying that you are happy with the accommodation in its entirety, not just part of it. Okay? You have a disability and for whatever reason you're unable to get around to the next room, to get in the apartment, to fairly use the windows, the light switches, the sockets, any of that stuff. This law is applicable, and there simply will not be an argument. There's not going to be any compelling argument from a landlord or the housing authority. Let me tell you something. Don't be scared to go toe-to-toe with the housing authority. I deal with them all the time. I'm not scared. Most of the people that work at housing authorities, to be frank with you, and I'm not trying to be ugly, but most of them, I feel like, get their diplomas out of a bubblegum machine. Most of them are poorly educated, low-paid, and have really... I get the consensus that a lot of them have not even read their own manuals. They have a very vague understanding of federal law, and they're really just kind of like secretaries working in a building. I think there's probably less than a handful of people that actually work in the housing authority that actually have anything better than a bachelor's degree or any fine understanding of how their own policies and procedures work. Most of you know that I have purchased most policies, procedures, and data manuals for most housing authorities in the country. So I know exactly the rules of which they must play by. And in addition to that, we're talking about federal, state, and county laws, including all of these modifications and accommodations. So me compared to them, that's not, them to me would be a complete joke. You're not, you wouldn't have much of a chance to refuse me on request. Trust me on that deal. Okay, so we're going to move on. The Fair Housing Act makes it unlawful to refuse or make a reasonable accommodation to the rules, policies, practices, or services when such accommodations may be necessary to afford a person with disabilities an equal opportunity to enjoy the dwelling or public or common use areas. So, another thing I want to discuss with you guys, it goes back to sidewalks, ramps, and parking. If these things are a true painfully hard to get around, you don't need to be in a wheelchair. Okay, you do not need that. Any type of disability, including mental disabilities. So let's talk about Section 504. Now, it does get a little bit more interesting with 504. Unlike the Fair Housing Act, Section 504 does not distinguish between reasonable accommodations and reasonable modifications. Instead, both are captured by the term reasonable accommodations. Under Section 504, the requirement to make reasonable accommodation applies to any changes that may be, and here's the key word, necessary to provide equal opportunity to participate in any federally assisted program. That is just a really neat word for saying the housing authority will comply with what I tell them to do. Okay? You have a disability, they have an attitude, I'll go fix that attitude, okay? So beyond that, we're talking about programs and also activities, including colleges. This includes a change, adaptation, or modification to a policy, program, service, facility, or workplace, which will allow a person with a disability to fully participate in the program. Back to schools, churches, all those places, and back to also Section 8 housing, HUD housing, and wherever you're living, okay? Under Section 504, reasonable accommodation must be provided and paid for by the housing provider. Another neat word for housing authority, the college, university, or school. Now, remember, when you start doing modifications to build, $10,000 wheelchair ramps, stuff like that, you could run into some lawyers and issues with that. Now, for the most part, if you have a problem with, say, your accommodation where you're living, it doesn't allow you equal access into the shower where you can roll in or easily walk in, or it doesn't have a bathtub and you're forced to stand up, it doesn't have rails and things like that. Those are simpler modifications, but when you start getting into structural changes, you may find that it may be a bit of a legal battle between attorneys, your attorneys, and theirs. Unfortunately, when we get in the arena of trying to actually adjust the structure of a building, that's when you really don't want to use me for that type of service. I can send, we can send formal paperwork, but I think that you probably want to go ahead and go and address what they call a housing advocate, which is actually a lawyer offering services free in your city. So moving on back. So back to dwelling in a public common area, use spaces, and remember the common use spaces. So this can include anywhere. It could be around the swimming pool, it could be down the hallway, it could be in the kitchen, it could be in a driveway. It doesn't matter. The sidewalk, for all I care. You could sue them for every sidewalk if that need be the issue that's at hand. But I would not recommend just attacking everybody for any old reason. Okay, so they take this stuff very seriously. Now let's go over the American with Disabilities Act, which is ADA. Similar to and based upon 504, reasonable accommodation requirement, Titles 2, 3 of the ADA requires public entities and public accommodations to make reasonable modifications to policies, practice, or procedures to avoid discrimination. Look, when we're talking about discrimination, we're talking about all forms of discrimination. If you're not being serviced, modified, or if you're not being given the accommodations because of your religious beliefs, because of your sexual preferences, if you're gay, or you're straight, or you're disabled, or you're a senior, or you're black, or you're white, these are all under the discrimination things. So if there's a particular attitude from a particular employee, and that is being administered as an excuse to not give you the reasonable accommodation because of all those different reasons, and many, many more, then there we do in fact have a case in that way too. So it's all, one thing I want to explain to you guys, it's all about the formalities with this. If you're going and you're dealing with a college, a school, a university, a business, or even a housing authority, you don't address it verbally over the phone. You start sending certified letters with the appropriate stuff. Don't take things we'll take care of it. We'll look at our options. We'll get back with you. If you don't have evidence and you're not actually keeping a trail of paperwork, then there's no evidence really that they've been neglecting you. So you guys have got to do your end. You've got to start building up your evidence of these things. And you need to be cautious. And don't worry about the housing authority and schools and universities trying to put you out and all that. Look, there's always going to be an attitude when you actually force them to actually earn their paycheck. That's what it comes down to. Anytime you're going to make these people work, spend money, and also earn their paycheck, of course they're going to have attitude. Especially when they feel that you're apprised and understand what the federal, state, and county law is. That really pisses them off because a lot of them have to go and race back to their office, get on the computer, and then refresh themselves on laws they've never even read. So they get mad. Oh, well, how do they know more than me? I'm supposed to be the person in charge. Always make sure that you know and understand what you're doing. If you don't, hire a consultant or hire a lawyer if it gets real serious. Let's talk about reasonable accommodation. Reasonable accommodation is a change, exception, or adjustment to the rule, policy, practice, or service that may be necessary. And it says the exception, adjustment, the rule, the policy, the practice, or service. Look, let's make it clear, everything. Okay, everything. Anything and everything, pretty much applicable, unless it's just unreasonable. Now, what could be considered unreasonable? Well, look, the housing authority, the school, and the college don't get to determine what's reasonable, what's not. A judge can determine it. The federal law can determine it. Your legislature can determine it. Never, that's the thing about this. If you have a problem, if you're looking to the person or agency or the building or the housing authority that's causing you the problem to educate you about what your rights are, you're out your mind. They're never going to do that. It's not in their interest to sit there and first not offer you something and then educate you on how to force them into providing these services. That's where you go to consultants and lawyers. Anyways, back to that rule, policy, practice, service may be necessary for a person with disabilities to have an equal opportunity. So, we've been talking about whether or not it feels good, if it's to enjoy, to afford, to feel great about the place you're living, but it also says an equal opportunity. In other words, if the man with two legs down at the housing authority, if the person can walk and talk and whatever, So if they're going to give accommodations to anybody, then they must especially give it to people with disabilities, whether it be drinking disabilities, drug disabilities, mental disabilities, physical disabilities, learning disabilities, all those type of disabilities, if in some way that it impacts you. But the thing is, you need to be really serious and consider what you're trying to approach these with, because if it's nonsense, then you'll probably not be taken seriously in the future, okay? And any change in any way, these things are customarily done that enables a person with disabilities to enjoy housing opportunities or meet program requirement is a reasonable accommodation. In other words, reasonable accommodation eliminate barriers that prevent persons with disabilities from fully participating in housing opportunities. Housing authorities, Section 8, your landlord, and so on, including private housing and in federally assisted programs or activities, housing providers that may not require persons with disabilities. Now, I'm going to go on. Housing providers may not, and I'm going to say that any of them, may not require a person with disabilities to pay extra fees, deposits, or place any other special conditions or requirements as a condition of receiving a reasonable accommodation. In other words, if they say but or if or in anything that they try to add on to this, that's illegal, okay? And here's what I'm going to tell you. It's not just a law. These are not just laws that are written, and they're not just federal laws. These are the type of laws that when you break them, you can go to jail. You can get sued, okay? So these are very serious. These are not suggestions for these people. These are the law. If you don't follow the law, what happens? You go to jail, right? If you break a federal law, what happens? You go to federal prison. I'm not suggesting the housing authority employees or people at your school are going to go to prison, but I'm going to tell you that when you violate federal rules, there are very serious consequences. Going back to housing authorities, these guys receive federal fundings. What happens when all that gets cut off? If they don't, let me tell you something. A lot of housing authorities are getting sued currently by HUD in Washington, D.C., or suing individual housing authority for discriminatory practices, and that's not even including modifications and changes that I'm getting a lot of requests about. All right, so let's move on. Since the rules, policy, practice, and services have a different effect on persons with disabilities than other persons, treating persons with disabilities exactly the same as others will sometimes deny the person with disabilities an equal opportunity to enjoy a dwelling or participate in a program. Not all persons with disabilities will have a need to request reasonable accommodation. However, all persons with disabilities have the right to request or be provided reasonable accommodation at any time. You understand, let's be very clear, at any time. You don't call and they say, well, come, why don't you message me in a month? This law says at any time. Not when it's convenient for them, not when they're going to get around to it, not when they've had their done yoga and taken a sip of coffee. It's immediate, okay? They need to process that. It's not a verbalization. You either provide me with the form or I'll provide you with a consultant, a lawyer, or a lawsuit. Comply or be dealt with. Under the Section 504 and the ADA, public housing agencies, other federally assisted housing providers, state and local government entities are required to provide and pay for structural modifications as a reasonable accommodation and or modifications, all right? There are no exceptions. I don't give a damn if it's the governor's house, his office. I don't care if it's the police station. You'll comply with the federal law or you'll deal. You'll be ready to deal and pay out. Reasonable modification. Under the Fair Housing Act, a reasonable modification is a structural change made to existing premises, occupied or to be occupied. I'm about to move in, so I suggest you make the changes. All right? That's how that works out. There won't be any discussion. There won't be any debate about it. If you meet the federal criteria, then you need to go ahead and call the maintenance department and start making reparations immediately. If you're not, then that's considered. Then we can discuss how that becomes discrimination, and then we can immediately move that to a court. So, under Section 504, the housing provider is required to provide and pay for structural modification as a reasonable accommodation unless it amounts to an undue financial or administrative burden. Okay, let me tell you something. That's open interpretation, but let me tell you something. I could see making serious structural changes, but as far as asking the landlord or the housing authority to simply do their job and do federal law. In other words, if they're going to try to rebuff that, then that's not going to work. If you're unable to complete your job as a housing authority employee, then you can simply be terminated or find a new job. Simple as that. If you're unable to understand or in principle be able to use a printer and a keyboard, then it's time for you to quit your job. Same thing for colleges, schools, and business owners. If you're unable to comply with the federal law, then it's time for you to check out. All right? So, I've enjoyed making this video. I'm very serious about this. Let me tell you something, folks. One thing you guys don't know. My father is John Roulette. He passed away at 55. He was a paraplegic, which means he didn't have use of the hands or legs. Now, he has some limited use of his arms. Now, I'm going to make this clear that he is my adopted father. He's not my actual real father. I fought these discrimination cases with him all the way through the 70s, the 80s, and 90s. Let me tell you something. I've got probably over 40 years combined experience watching my father and me also growing up dealing with ADA issues, bad business owners, bad landlords, bad housing authorities, all kinds of stuff going on. So this is something in principle I know very well. Again, I want to tell you that I am discussing the federal laws as they are presented. And I want to make it also clear again that I am not an attorney. I am not trying to specifically interpret the law. I'm telling you the facts and opinions that I have. And as a consultant, when I deal with housing authorities, I'm especially good at, let's just say, compelling them to cooperate, okay? When my compelling doesn't work sometimes, when they're ready to lawyer up, then of course you find yourself in a situation where you may have to hire an attorney to finish that process out. So look, I've enjoyed talking with you guys. I hope this has shed some light. I did all this in big print. Hopefully you can see it better. I'm sure there are people that are on YouTube that are probably have a better Hollywood. They're more of an entertainer than I am, but I wanted to get straight to the point so y'all could see it, so you could read it, and hopefully understand what some of these things meant. So, y'all have a good morning, and we look forward to speaking to you again. Bye-bye.